evening, everyone, and a very warm welcome to today's session on economics of intellectual property rights. It is a pleasure and honor to have Professor Alka Chamla, Professor in Charge, Campus Law Center, University of Delhi, New Delhi. We welcome you, ma'am, and thank you so much for graciously accepting our invite. I also welcome Muhammad Tayyab Alam sir, Communication and Documentation Officer, Moraji Desai National Institute of Yoga. We are very grateful for your kind presence, sir, and your valuable inputs on this program. Thank you for being a part of the session. As a part of the tradition of the Institute, we will begin the session with prayers. Astu ma sadgamaya tamso ma jyotirgamaya mrityurma amritam gamaya. Om Shanti Shanti Shanti. I again welcome the speaker, Professor Alka Chamla, Professor in Charge, Campus Law Center, University of Delhi, New Delhi. We deeply appreciate your gracious presence, ma'am, and willingness to share your valuable insights and experiences with us. Thank you so much, ma'am. I now respectfully request Muhammad Tayyab Alam sir, Communication and Documentation Officer, Moraji Desai National Institute of Yoga, whose continuous and steadfast support for helping us in this webinar series was we are highly grateful for that. And to introduce the speaker, I now invite him to introduce Professor Alka Chamla, ma'am. Please, sir.
Thank you, Dr. Suman Rathore. Good evening, everyone. Respected Professor Alka Chamla ma'am teaches at the Campus Law Center, University of Delhi. Ma'am was featured in the top 100 powerful women in law list released by the World Intellectual Property Forum in 2021 and 2017. And received the Women of the Decade Award from the Women Economic Forum. Professor Alka Chamla ma'am is nominated as a national expert on intellectual property by the European Trade and Business Council, mentor to the Intellectual Property Protection Organization, advisor to National IP Organization, and a member of Education Committee, FICCI, etc. Ma'am is the recipient of the Teacher of the Year Award 2018, given by the Indian National Bar Association. Professor Alka ma'am has authored books on copyright law and written a number of articles and research papers in reputed journals. Ma'am is the author of a well-acknowledged report on counterfeiting and piracy in India, a project of Organization for Economic Cooperation and Development. Professor Alka Chamla ma'am has presented and well-researched papers at national and international conferences and workshops. Ma'am has delivered lectures at various institutions, renowned institutions across the world. With these few words, ma'am, thank you so much for accepting our invitation on a very short period of time. And this Friday webinar is quite popular in different social media friends, students, staff of the institutes. With these few words, now I would like to request today's esteemed speaker, respected Professor Chamla ma'am, to share her views on in fact, a quite excellent topic, economics of intellectual property rights. Ma'am. Please unmute you, ma'am. I think you are muted.
Your PowerPoint presentation is visible, ma'am.
Okay, can you hear me now?
Yes, ma'am.
Okay, okay. I'm so sorry. Though we had this, it always happens with old people like me.
Sorry, ma'am. It happens with everybody.
All right. Thank you so much for inviting me. Thanks to Dr. Suman also. I did not know who Dr. Suman is, but the way she spoke to me, it was such a sweet way of asking me to speak. So I had no option but to say yes. So thank you, Suman. I'm going to speak about economic significance of IPRs today. Should I broaden the screen?
Yes, ma'am.
All right. So, this topic actually has become very, very important, especially in the era of globalization, because you will find that it gathered a lot of momentum, especially with the Uruguay round, which continued from 1986 to 1994. And what this Uruguay round basically did was that previously we had GATT, that is General Agreement on Trade and Tariff, and GATT did not cover intellectual property rights. But as the world, the commercialization began, you will find out that there was more and more need of including intellectual property into the trading circles. So GATT gave way to WTO. And within WTO, as we all know, there are around 28 agreements. And one of the agreements is agreement on trade related aspects of intellectual property rights. So in the morning, it was moving so well. Why my PPT is also not moving now? One second.
Maybe there's some internet issue.
Is it visible now? Is it visible
No,
to you?
ma'am. No, ma'am. The PowerPoint presentation is not visible. And if you want, you may share the presentation with us. You can share that PPT with me, and then we can share the screen the PPT from our
No,
end.
no. I mean, I've been lecturing so much. Just give me 2 minutes.
Okay,
I'm
ma'am.
so sorry for this. I think there is some internet problem.
Ma'am, you can share the PowerPoint presentation. I'll give that to the tech team, and then we'll screen the PowerPoint presentation from our end.
It, that's perfectly fine. All right. Uh, it is ending now. Hello.
Hello. Ma'am, your voice is echoing. Maybe,
I know. So what do I do?
ma'am, if you are opening it from phone as well as from laptop, you
No,
can.
I'm not on the phone.
Okay. Then, ma'am, try to log in again.
All right, I'll do that. Hello. जल्दी बोलिए प्लीज, आई एम इन द लेक्चर. हाँ आ रहे, मैं आपसे प्लीज 1 घंटे में बात करती हूँ. आई एम सो सॉरी, आई एम इन अ लेक्चर. हेलो, यस सुमन. This is a very difficult thing. Just give me a second.
I guess we are good to go with the presentation or with the lecture session.
All right. I can hear my own self. Is it happening here also?
Ma'am, actually, you need to mute yourself from one of the phones.
No, but my phone is not working. reference under it is TRIPS, which is dealing with intellectual properties. And we all see that, this entire 21st century, it is known as knowledge economy. You started with a prayer, and I think two of the Devis or goddesses which become very, very important today are Saraswati and Lakshmi. There was a time when we were small, when people said that Lakshmi and Saraswati were two stepsisters and they couldn't go hand in hand. But I think today is the time which is called knowledge economy, where if Saraswati is there, only then can we find, Lakshmi. Otherwise, it becomes difficult for Lakshmi to be present. That is why and we've seen that the major this economic growth, this has been one of the major reasons and causes for phenomenal rise in the study and importance of intellectual property over the years. The protection and enforcement of IPRs, these are the major components of international trade and scientific cooperation. The IP intensive industries, whether it is copyright or patents or it is geographical indications, you will find that they are one of the fastest growing economic assets of our country. In 2016, National IPR policy was announced by the Government of India, and it visualized India as India as a place where knowledge was to be the main driver of the development. And in fact, if you read National IPR policy, you will find that the IP assets have been referred to as economic assets. So, because when we call them economic assets, only then do we say that they are becoming a part of the economy. Wherever another important fact that we find in the legal fields is that if anything is protected and enforced properly, that means if there is an adequate IP protection and enforcement mechanism, then that is going to support numerous societal, consumer, economic benefits it is going to have. But if the IP protection is inadequate, if the IP enforcement is inadequate, then we will find it is working in exactly the opposite direction. People always say IPR without understanding what IPR means. So I think as talking about the economic structure, I would also talk about what IPR stands for. Under TRIPS, there are some things which are covered, that is copyright and related rights, trademarks, geographical indications, industrial designs, layout designs of integrated circuits, and undisclosed information, which we normally refer to as trade secrets. These are different IPRs which are covered under TRIPS. And we will find that in India and also in and also in other countries, wherever there is if there is copyright, there is a Copyright Act. If there's trademark, there's a Trademarks Act. Geographical indications, there is a separate act. So for every of the topic under TRIPS covered by IPRs, there is a separate legislation which is present. Separate legislation means the way any property is acquired and how we maintain rights. For that, one will have to look into the entire system or the gamut of the legal structure. So I'm going to deal with them one by one. Let us look at trademarks first. We all know, I'll first show you what trademarks look like. Let us look at this one. The moment I say Fevicol, or the moment I look at those two elephants facing in different directions, I know it is Fevicol that we are talking about. Coca-Cola is the brand name, what we refer to as the trademark for a black colored drink. MasterCard, Parle-G, these are all different kinds of trademarks which are present. Now, how is trademark working in any system? Trademarks protect the rights to market goods and services under distinct names and symbols. And why, any businessman works very hard in order to protect its trademark, its brand name, because it is this brand name which is speaking about a quality. Whenever you say that you want to buy only, say, A brand of toothpaste and not B brand of toothpaste, why you are saying this is because you are very happy with the quality of a particular toothpaste. So trademark plays a very, very important role in marketing of goods and services. And it is very, very important to protect your trademark. And why you need to protect your trademark is because you want to protect it from passing off by lower quality goods firms. I'll just show you one or two pictures. Let's look at this one. The moment you look at this, if audience was right in front of me, I would have removed the slide and asked you, what is it? And mostly everybody says it is fair and lovely. But if you look at all these three boxes, you will find out one is fair and lovely, the other is pure and lovely, the third one is charming and lovely. Now, what was the reason for all these people to use similar names to fair and lovely and make similar packing like this? The only reason one can think of is that you want to pass off your goods as if they belong to someone else. So this creates a kind of a parallel system within the trademark system. And this is something which needs to be protected. One more picture I'll show to you. Look at this one. Colgate. None of these two is Colgate. It is either collegiate or it is clogged. So, and this is not something that we are looking forward to. Let me come down to geographical indications. This is the second kind of property that one talks about. We have, I don't know, actually, I do not know whether the audience knows about these IPRs or not. Anyway, I'll go with the presumption you know a bit, but you don't know much. So I'll go with that presumption. Now, as far as geographical indications are concerned, the entire protection system is same as the trademark system, but the only difference is trademarks belongs to individual proprietors, whereas geographical indications belong to a particular region. Let us take an example. The moment I say Darjeeling tea or Kangra tea, you immediately think of Darjeeling and Himachal Pradesh. If I say Kolhapuri chappals, you know that it is coming from a particular area in Maharashtra. If I say Kota Doria, you know it belongs to Rajasthan. So why are we equating or why are we looking at these names with such reverence and respect today? The answer is that these geographical indications, they have started playing a major role in trade between countries. And the moment we give protection to these geographical indications, that means we are recognizing the rights of that particular area, the region where either the goods are manufactured or they are grown. So this is applicable to both manufactured goods and to natural goods. GI protection, when we give legal protection in the form of geographical indications under the Geographical Indications Act, we find that there have been studies which have been made that it encourages livelihoods of people, it encourages employment of people, and now those who have got the GI registered, they will find that their products are being sold at a higher price. And these geographical indications are normally related to people in the rural areas, people in the areas where there are the farmers or the non-farmers, all people are, or different kinds of people are there. But why it is coming to help of rural and people and artisans is because the moment we give GI, it creates a fame in the market and it creates a kind of a name which other countries also start recognizing. So by having this, what we can do is we can capture the entire market relating to those goods and create barriers for the fakes. And the introduction of this Geographical Indications Act came in India in 1999 after WTO. And you will find that throughout the world, rural communities, they have developed typical products. And after this, with interactions with different countries, they have been able to increase their economic market. As far as geographical indications are concerned, I thought again I would not spend much time on it. I would rather spend little bit of more time on patents. So we have trademarks, which are the names of goods and services. We have geographical indications. When we come to geographical indications, there are two kinds of registrations which take place under geographical indications. One is where the entire state or the community gets the registration. And the second kind of registration is those who are the authorized users. So only those people can make use of GI and nobody else can make use of it. Coming now to the third category, that is patents. Now, as far as patents are concerned, any invention is patentable. If it is new, that means if it has the characteristic of novelty, if it is non-obvious, meaning that nobody could ever think about it, nobody meaning even the expert in that particular area could not anticipate that such kind of a product or a process can be made available. And such an invention should be industrially applicable. If these three criteria are there, one, that is, there is novelty which is present, that means it is something new. There is an inventive step which is present. Two, it is not obvious even to an expert. And third, if it is industrially applicable, one can make an application to the patent office for grant of a patent. And if patent is granted, it would be granted for 20 years. But this 20 years begin from the date of the application. So practically speaking, you will find patent is given for a lesser number of years, though the Act says it is given for 20 years. Because there may be a gap of 5 to 6 years between filing of an application and granting of a patent. We all know when a patent is granted to a particular person, he is called patentee and he gets a monopoly in that particular product. So he is the only one who can commercialize it. He is the only one who can give license to anybody else to make use of it, unless and until there is some kind of a national emergency or health emergency under which compulsory licenses can be given. But we have seen in practice that compulsory licenses are not given so easily. It is only when there is a national emergency which is present. Now, in Patents Act, there is one which is Section 3, which says that all inventions are not patentable. So just giving you an example of some of the inventions which are not patentable are, see, one is this: any kind of a frivolous invention is not patentable. If it is immoral, unethical, then it would not be patentable. Something for our purpose, let me say, is the Section 3, Clause I, which is saying any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free from disease or to increase their economic value or that of their products is not patentable. Another such example is an invention which in effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component or components, is not patentable. Meaning thereby that if somebody knows about a particular product, then it would not be patentable. If some knowledge is available in public domain, then it should not be patentable, right? Now, the problem comes with respect to traditional knowledge, and that is what the problem that we have been facing. Neem got patented, basmati rice got patented, and there are so many other such examples. Now, what is traditional knowledge? Traditional knowledge, we all know, we've heard about, Nani Dadi ke nuske. The problem with our country is when it is a Nani Dadi ka nuskha, says your Dadi tells you, if you get hurt, she tells you, haldi wala doodh pee lo, to sabko problem hai. लेकिन अगर कोई अंग्रेज ले आएगा एक हल्दी वाला दूध और उसको बोलेगा have this latte, turmeric latte, and he'll send it for some exorbitant amount of money, then people will have it. But then a time has come when we are not simply to follow the West, we have to realize that there is so much of wealth of knowledge which is present in our country. So how do we protect our traditional knowledge? I just got the statistics. In India, there are about 6 lakh licensed practitioners of classical traditional health system, and there are over 10 lakh community-based traditional health workers. And intellectual property rights sector, it has the potential to protect all this. It is very surprising that traditional knowledge is not covered by TRIPS, and we have to ourselves deal with this particular area. Now, the question is, can traditional knowledge be patented? The simple answer to that is no, it cannot be patented. Why? Because it does not have the concept of novelty. It does not have non-obviousness. It may be industrially applicable. But the first criteria, that means it has to be novel. Novel means new. New means nobody should have known about it. That is missing. Because the very word traditional knowledge shows that it has been traditionally present. We know a number of examples where, the European Patent Office and the US Patent Office, they granted patents to our traditional knowledge. So we had to fight out in WIPO to say that all these inventions are not taken up by them, they are not inventions by the Europeans and the United States people. In fact, they are present in prior art in our own country. Prior art means a knowledge base which is already available in a particular country. And we have won those cases. But after winning the cases, we realized that why is it that they could have an invention using our knowledge? The answer was that we had not documented our knowledge. And since we had not documented it, it was not available in the searches. So this led to creation of traditional knowledge, what we refer to as TKDL, that is Traditional Knowledge Digital Library. I think we've all heard about it. Now, this Traditional Knowledge Digital Library, if you see, this is having a lot of everyday documentation is taking place with regard to traditional knowledge. So I've given in this slide that since traditional knowledge is in public domain, therefore it cannot qualify as invention under Section 21J of the Patents Act. If somebody files an application for grant of a patent using traditional knowledge, then it can be refused under Section under Section 25, or under pre-grant opposition is there. So 25(1)(a), where you have 25(1), where there's pre-grant opposition, and 25(2) is even if by mistake a patent has been granted, then a patent can be revoked by using Section 25(2)(d), F, and K. In India, I need not tell you all these things. I think you know it better than me, that in India, there's a Department of Ayush, that is Ministry of Health and Family Welfare, Government of India. They have launched what they call it, National Ayush Mission, which is acronym is NAM. And the basic objective of NAM is to promote Ayush medical system through cost-effective Ayush services, strengthening of educational systems, facilitate the enforcement of quality control of Ayurveda, Siddha, Unani, and homeopathy drugs, and sustainable availability of ASU and H raw materials. Now, it envisages, what the STAM envisages is flexibility of implementation of the programs, which will lead to substantial participation of the state governments. NAM contemplates establishment of a national mission as well as corresponding missions in the state levels. NAM is likely to improve significantly department's outreach in terms of planning, supervision, and monitoring the schemes. Why are we saying so much about intellectual property is because there are so many studies which have shown that nations with strong IP ecosystems, they are attracting venture capital investment for research and development and for commercialization of innovative products and services. IPR actually can become an important drawing card for innovative startup firms to get access to funding from investors, including venture capitalists. And there are so many schemes which have been started by the government for startups. And once a startup, it reaches a certain stage of development, the fact that it has turned its R&D into a patented asset, for example, if the moment it turns into a patented asset, you will find that is a great signal for a good management, and it demonstrates that the firm has defined and carved out a market niche for itself. There is a very, very strong positive relationship between venture capital funding, patenting, and innovation. The patent ownership of early stage high technology companies has a positive impact on the timing and value of venture financing received and on the likelihood of attracting prominent capital investors. With this, I would like to, further mention, this TKDL I've already mentioned to you. I think the slides got up and down. I'll just read it out. TKDL is set up. It's a unique tool to protect traditional knowledge. It's available to, that's something important. This is available to all patent offices that have signed TKDL access agreement. And it's a collaborative project again between CSIR and the Ministry of Ayush. Result is that hundreds of applications have been identified relating to the Indian medical system, and they have been placed in the document here. And once they are documented, no one can make use of our knowledge. What is the effect of wrongful patents? The effect is that I have an exclusive right on that knowledge. Somebody else gets a patent means now he has an exclusive right to exploit knowledge in the country in which the patent was granted. So what will happen? If another country gets a patent, that becomes a threat to the Indian producer here. And it also acts as a demoralizing, demotivating factor for me, because I will have a feeling that my knowledge has been used by someone else to make money. I will go under emotional distress because I will see that the others have trespassed into my knowledge. And when that happens, there is a problem. When we have a patent system, simultaneously, we also have a trade secret system. Why I say simultaneously, these two work in slightly opposite directions. A patent is granted to a person as a quid pro quo for disclosing one's information. Meaning, I have certain information with me. I go to the patent office. I file specification and my claims. And in the specification and the claims, I have to give the best methodology. And for that, a patent has been granted to me. So my disclosure is made to the patent office, and in return, patent office is giving a monopoly to me, right? But the moment it is disclosed to the patent office, it becomes a public document after a patent has been granted. Becoming of a public document means now anyone can use it for further study, for further inventions. But what happens when you keep something as a trade secret? Trade secret means only you know about it, and you're not disclosing it to the entire public which is present. So a secret is being kept by you and for the generations to come to whomsoever you want to give the secrecy. Now, the question that is very frequently that is asked is, should I get my product patented or should I keep it as a trade secret? Now, these are purely business options and propositions. So one cannot force you to have a patent and one cannot force you to have a trade secret. That entirely depends upon the person as to how he wants to make use of it. Now coming to, yoga, what would be your, if I may ask, what would be your inquiry? First of all, the question can be, can yoga be patented? The answer is no, because Patents Act is talking about either a product patent or a process patent. But a process patent is one which leads to creation of a product. Now, yoga is not creating any product as such. Therefore, there can be no patent on it. One. Secondly, it is a part of our traditional knowledge. It is there in our system since ages. Therefore, one cannot even think of creating monopoly. When it belongs to our culture, when it belongs to our society, when it belongs to our country, nobody can be allowed to monopolize it. Many times, people get confused as to what kind of a monopoly are then people creating. What happens is, you may have pictures of yogasans in a book. So when you have pictures of yogasans in a book, those pictures are copyrighted. And now you will not move into the Patents Act, but from here you will have to move into the Copyright Act. So what is Copyright Act saying? Copyright Act is saying that if you have a copyright in your work, then you have a right to reproduce, right to make a film, right of adaptation, right to store, and so on and so forth. That means only as far as those pictures are concerned or the writing is concerned, that cannot be reproduced by anyone. Right? But someone can use one's own expressions in expressing it. So from here, we will move down to the Copyright Act in India, which is the Copyright Act of 1957. If you look at the Copyright Act of 1957, you will find that the industries, I'm sorry for the small font here, the industries which are which are being covered by the Copyright Act are the publishing industry, the entire entertainment industry, whether it is Bollywood or it is music, I mean, whether it is films or music, your animations, softwares, these industries are covered by intellectual property. And if you, look at the WIPO readings, they will say that creativity plus copyright leads to jobs and economic growth. So we can see that whichever intellectual property that we talk about, there is some economics associated with it. There are a number of tools which have been used by various countries for the development of their IP assets. And as I told you, that even in our country, when the National IPR policy was announced in 2016, intellectual property was referred to as economic asset. The moment we call it a property means that we can possess it and we can dispose it of, we can alienate it, we can sell it, and we can get money out of it. The very concept of property is taking it to economics. And very categorically, the IPR policy is saying that intellectual property is one of the economic assets of a country. And we will see that, these IP-based industries, they are the significant drivers of GDP and employment, both in the developed and the developing countries. And IP-dependent businesses, they're becoming an essential and rising element of every modern nation, especially as the economies, they are moving from agricultural, mineral, and low value added industries. They're moving towards high value added products and services. You will see that they're all related to some kind of an intellectual property or the other. Some of the tools I thought I'll just mention is there are many countries which are providing for funding and cash payments for development of intellectual property. In many countries, tax incentives are given if you are in IP intensive industry. There are awards given for inventions, for utility models. Utility models are basically petty pen inventions that we are talking about. In India, we don't have a law on it, but in Japan, China, in US, even utility models, they are patented. Then with respect to creativity in schools and universities, we are giving awards. There are employers' incentives. If employees are creating IP, they get certain bonus. There are certain insurance IP policies to promote local IP against risk of the technology not being successful. There's coordination among different agencies affecting IP policies. There are different policies which are given by the government, especially for the startups. So I would like to say that if ever you're thinking of getting into the field of intellectual property, if we go step by step, we will not make a mistake. The first thing that one needs to do is you have to identify what is the kind of property that you're creating. If it is an invention, go to patents. If it's a drawing, painting, writing, film, episodes of a serial, photograph, go to Copyright Act. If you're talking about naming of a product, go to the Trademark Act. If you're talking about certain peculiar manufacturings or natural products, then you go to the just excuse me for a minute, please. Sorry for the disturbance. Then one will have to go to the Geographical Indications Act. So only when you identify your property, you go to a particular act, and then you find out what your rights are, how they need to be protected, and how the infringement is taking place. So with this, I think I will just put a stop. And if anyone has a question or if you want to discuss about something, then I would like to do that.
Thank you so much, ma'am, for presenting such an engaging lecture. And there are a few questions which we have received from our viewers.
Yes,
So
please.
one of the questions is, digitization has always made it easier to copy and distribute digital goods like movies, music, software.
Yes.
So, which has led to debates over appropriate level of copyright protection and the balance between protection and access to information. So, what are your views on it, and how do you assist with working on such breach of IPR rights?
All right. See, one thing that I want to say is in such a small span of time, it is very difficult for me to deal with everything. But one of the fundamental principles is that whatever law is applicable for print media would also be applicable on the digital media. So, because what is after all digital media? Internet is only a system of communication. So if you need permissions under print, you also need permissions under the digital media. And as the digital media is increasing, we can't stop technology. We have to bring law in alignment with the technology. But what we find is that, all these YouTube or any of these things where you can upload or any of the social media that you take, they've started having an IPR policy now under which you can make a complaint if you think that any of your intellectual properties are violated, and then the complaint is taken care of.
Okay, ma'am, there's another question which we have
Yes.
received from the viewer. That is, what are the economic incentives for researchers and institutions to conduct research in the field of yoga when it falls in the category of traditional knowledge?
The schemes.
Incentives. What would the institutes or the researchers, what kind of incentives would the researchers or the institutes get when they work in these areas?
See, this is, as I told you, this Ministry of Ayush, you are the ones who are dealing with all this. You would know better. That Ministry of Ayush is now developing, a lot of schemes. But what are exactly the schemes? I do not know. That you will have to find out. But one thing I can for sure tell you, that a lot of funds are being released by the government if one is working on any of these research projects. So you can be a principal investigator. You can have an agreement with, that's saying that whatever you create, you have a copyright on it. It is actually, you have to have proper agreements for setting up specific schemes. I would not know.
Okay.
But what I can tell you is that, for startups and all, for medium, small industries, MSMEs, there are lots of schemes coming up, and I'm sure Ministry of Ayush would be releasing certain schemes for yoga also.
Okay. So, ma'am, I wanted to know if a unique app or protocol has been developed by certain expert after carrying out various experiments. So, won't that be patented?
See, this is a very broad question. Again, ECHO has started. On procedures, on applications, there is no patent which is present. But because, as I told you, patents is only for creation of a product. You will get a patent for a process only if it results into a product. And algorithms, etc., have been very specifically, I will just tell you 1 second. Where is this? Okay, section 3, what I can suggest to you is, please read section 3 of the Patents Act. And under it, there are a lot of exceptions which are given. And you will find all these exceptions under section 3.
Okay, ma'am. And how do intellectual property rights affect the economy of developed countries and developing countries?
That is what exactly I told you, that they are, since these are, let's take, for example, films, Bollywood. The amount of money, it's all a copyright intensive industry. You invent, you make products. If wherever you're sitting, the chair on which you're sitting, the garments that you're wearing, you may have applied certain chemicals on yourself, you're writing with a pen. All these developments, they are all basically inventions. So they are contributing to the economy as either products or as creative industries.
Okay, how is it different in developing nations in comparison to developed countries?
Sorry?
How is this different in developing nations when
This
it's
is not
when it
different.
is
The only thing is, if you look at most of the IPR laws, you will find out that they are trying to create a balance between the right of the creators and the right of the public. The entire concept of compulsory licensing, for example, when India talks about compulsory licensing of a patented drug which belongs to a developed country, there's a lot of hue and cry created by them. But if they have a compulsory license to our drugs, then there is no hue and a cry. वो आपने मत्स्य न्याय सुना है ना, चाणक्य का? The big fish eats the small fish. So the small fish will have to take care of itself. I can only say that.
So with this note, I thank you so much, ma'am, for presenting such an insightful lecture. It was quite engaging and it was a pleasure to have you with us today, ma'am.
Thank you so much. Thank you.
Thank you, ma'am. We will end the session with Shanti part and then we will conclude. Om Shanti Shanti Shanti. Thank you so much, ma'am.
Thank you.
Thank you, ma'am.